Hi, my name is Abby Hudson, and I'm an attorney at Carolina Family Estate Planning. And today I'm going to discuss with you how to update the title of your spouse's vehicle. As if losing your spouse isn't already devastating enough, you're now likely thrust into a bunch of legal paperwork and questions as you sort out your spouse's accounts. One of the situations that many of our clients discover is that their spouse's vehicle was titled in both of their names, and they're not sure what to do. First, locate the title to your vehicle. If you cannot locate the title to your vehicle, you can call the DMV and request a duplicate copy. But for today's purposes, I'm going to assume that you have located the car title. Once you've located the title, please review it and see how your names are registered. Is the title registered in you and your spouse's name? For example, John Smith and Mary Smith? Or is it registered with designations after the names, such as trustee or JTWROS? If it says trustee beside your names, this means that the vehicle is owned by a trust, and the trustee of that trust is authorized to manage the vehicle in accord with the instructions located inside the trust document. If you see JTWROS, this stands for Joint Tenants with Rights of Survivorship. If you see JTWROS, you can proceed to go to your local DMV and begin transferring the name of the vehicle into your own name. When you visit the DMV, please bring with you the car title, an original death certificate, proof of insurance, and a valid government ID, such as an unexpired driver's license or passport. But if you're like most people, I'm guessing you are not going to find a designation listed after your name. If this is the case, then effectively what the title is stating is that legally you own half of that vehicle and your deceased spouse owns the other half of this vehicle. What this means is that your deceased spouse's half of the vehicle is now a part of his or her probate estate. Now, don't panic just because I said the word probate. If you're like most married couples that we see, most of your accounts will likely be listed as joint with rights of survivorship, or you will be listed as the primary beneficiary on these accounts, such as retirement accounts or life insurance policies. If the vehicle is the only probate asset that you've discovered so far, then the probate process should be relatively straightforward. What you'll need to do is contact the Estates Division of the County Superior Court and begin claiming what's called a spousal allowance. Compared to full probate, the spousal allowance is a relatively straightforward process. The spousal allowance allows you to claim up to the first $60,000 of your deceased spouse's estate. The clerk of court will help you apply for the spousal allowance, but you will also need to provide an original death certificate, a car title, and the estimated value for your spouse's portion of the vehicle. This means if the car was titled jointly, you only need to provide half of the estimated value because you're only reporting the value of your spouse's portion of the car. The clerk of court will approve your application, and once it is approved, you can bring the document to your local DMV and initiate the process of transferring the vehicle fully into your name. I know this can be an overwhelming and confusing time. You're not alone. We help clients in these types of situations each and every day. If you need help figuring out your next steps, please give our office a call and we will help you with how to proceed.